Mr. Schiff.
Thank you, Mr. Chairman. I want to follow up on my colleague's question. And Mr. Attorney General, we had a chance to talk about the detainee issue a couple of weeks ago. I guess I would phrase it a little differently than my colleague, but much along the same thinking, and that is that I think the military courts martial are really the best venue for proceedings involving the vast majority of the detainees. There may be some, and ironically, it may be some like Khalid Sheikh Mohammed, who you decide to try in a district court for other reasons, because you want an even more public venue. But I think for balancing the national security needs as well as the due process concerns, the military courts have got a history longer than our country's been around of doing that very well. And I like the idea, frankly, of being able to hold up to the rest of the world and say, much as my colleague said, but in reverse, that we're giving the same due process to these people accused of acts of terror that we give to our own troops who are brought up on court-martial charges. I've introduced a bill along these lines, and I'd love to share it with my colleague, and I've talked with many of your staff about it. One of the features of it, though, in addition to trying most of these people in military courts martial, is a threshold question, and that is, are you going to be relying on the status determinations that were made under the prior flawed regime? There are two determinations that have to be made. One, are they unlawful combatants or unprivileged belligerents? And two, if they are, should we prosecute them and where? But on that threshold question, I would say that the prior proceedings were so flawed that they need to be redone. That threshold decision has to be remade about whether they are, in fact, unprivileged combatants. And I think that you can use the military courts martial and modify the UCMJ for that purpose. And I've got a bill that accomplishes that. And my question is, do you believe that you will have to redo the status determinations, or do you intend to accept status determinations made under the tribunals that were set up by the Bush administration? Yes.
Well, no, we're actually making new determinations. We're looking at all of the people who are at Guantanamo, for instance, with we're taking a fresh look, even with regard to those who the prior administration said could be released. We're looking at those as well to make sure that in applying the standards that we think are applicable, that we are being uniform in making those determinations. And so all of the people are being examined.
Well, if I can ask more specifically, though, I know you're doing a case-by-case determination, but in those cases where you decide you're not going to send them elsewhere, that they're going to be tried, the threshold determination that has to be made is, are they an unlawful belligerent? And will you be adopting what the Bush Tribunal's conclusion was, or will you be establishing a tribunal to make that decision de novo?
I think as we make these individualized decisions, we'll be making, again, individualized determinations about where, for that group of people who should be tried, where they should be tried. It could be in Article III courts. It could be under the Uniform Code of Military Justice, a great system, or it could be under military tribunals that I think would be different from those that were previously in place, that would have, from my perspective, greater due process components as a part of them.
You know, let me just take this another way, and that is, there's a separate question from where will they be tried. And that is the question of, are they unprivileged belligerents to begin with? If they're not unprivileged belligerents, if they're prisoners of war, for example, they're immune from prosecution as a prisoner of war in most circumstances. But if they're an unprivileged combatant under the rule of law, under the laws of war, they can be prosecuted. The Bush administration had tribunals that decided that they were unlawful combatants, but they were terribly flawed. Once they got through the tribunals, then they were brought before military commissions, where some of them were prosecuted mostly without success and overturned by the courts. But that first decision still needs to be made on anyone that you don't want to send back to their home country or release. I think the decision still has to be made, are they an unlawful combatant? And that's not an issue of whether it goes to, the threshold question, I guess, is, do you accept any of the determinations made by the Bush administration. And I will just advocate here. I would suggest that you don't. I would suggest that on the question of whether they're unprivileged, that should be reviewed de novo by a more competent tribunal. And then the decision should be made, where do they get prosecuted? So I would just commend that to you and thank you again for your diligence on this.
Yeah, I've not been clear, and I guess what I've tried to say is that I think I agree with what you're saying, is that we will be making new determinations, both with regard to what courts perhaps they are to be tried in and what their status is. We are not, for instance, using the term enemy combatant anymore. We indicated that in a court filing, I guess, a couple of weeks or so ago, so that the determinations that we're making are on the basis of a fresh look that we are taking, and based on the accumulation of all of the evidence that we can get from the various agencies that are involved in this process. And that fresh look really starts from the beginning and goes all the way through. So I hope I answered your question.
Mr. Lewis.